by whatever name would be responsible for overseeing without having to name names. With respect to the FID, their comment is on the entire clause 36, and essentially their concerns follow the same line that we discussed at our last meeting, essentially that the exemptions that are afforded them under this part doesn't seem to be absolute. There are things that they would still have to do if challenged. So they've said that the exemption is not absolute and is only to the extent to which the application of the disclosure to data subject requirement is likely to prejudice the proper discharge of the relevant functions. So that they also highlighted and would have raised a similar concern in relation to clause 34. And just to remind members, because I know that there are a few members that wouldn't have been here when we had the discussion, essentially what FID is saying is that while they concede that there are provisions within the legislation that would allow them to carry out their activities of detecting crime and so on, they felt constrained, notwithstanding by some of the exemptions, and felt that without absolute exemption, they would be hamstrung in some ways. Our contention, however, is that we believe that clause 34, which covers law enforcement activities, as well as this clause 36, which speaks to a regulatory activity or function being performed in accordance with the legislation, provides sufficient room for them to continue to do what they're doing without disclosing to the data subject, anyone they're investigating, what it is that they're doing. So we continue to maintain in relation to FID that clause 36 and 34 offer the FID the protection that they need, but we take and will, as indicated in our last meeting, have that conversation with FID. And just to remind members of what the recommendation was, recommendation from one of the members, and the members generally present, was that we should speak to FID, share with them how we interpret the provisions, and then see if how we've interpreted the provisions in the legislation would give some comfort to them in the performance of their duties. So that conversation we'll have, and certainly this is one of the sections that we'll be talking to them about. But we are recommending on review that section 36(2)(a) 2, a function of the government or minister or department of a government, and members might recall similar language before that we had said that as a ministry, when looking back at it, we thought it was too broad because we weren't sure that could be anything. When we talk about functions of government and a function of a minister, that would be exempt. If left as wide as that, that could mean absolutely everything and anything. So this would be a consequential amendment from previous recommendation, and a previous recommendation that was made in relation to how to treat with these specific language in previous clauses. I think the committee would have accepted those. So we raise this one again because this is here.
Okay, I put clause 36 with amendment to subsection 2.
So clause 2 of 36, A, 2, Roman numeral 2. To delete a function of the government, to delete a function of the government, a minister or a department of government.
Oh, to delete this, okay. All right. I put clause 36 with the recommendation to the committee members. Okay, clause 36 with amendment accepted. We'll move on to clause 37, journalism, literature, and art, and the exemptions for those activities.
So clause 37 addresses processing which is done for special purposes, and special purposes are defined as literary, journalistic, artistic, and literary purposes. We have two comments on that particular section, one from the Press Association of Jamaica and one from the Media Association of Jamaica. With respect to the Press Association, their concern is that, as it relates to clause 37.1, that the clause provides that personal data which are processed only for the special purposes are exempt. Allegations that publication is not only for the purpose of journalism could stifle the practice of journalism in a small, closed society. And their recommendation is that the word only be deleted in clause 37.1, the chapeau, as well as 37.4, and then again a little later on, we're not there yet, but at clause 52. So their recommendation is that the word only be deleted. With respect to clause 37.3b, they're recommending that this should be deleted because the section places the commissioner in a superintending role as regards the practice of journalism to determine whether publication would be in the public interest. They note that it creates a situation where the commissioner, as an agent of the state, is given wide and deep powers to censor and kill publications about other agents of the state. And then I'll just go to the Media Association of Jamaica. They believe that the section does not specifically say that it applies to pre-publication and to post-publications, and arguably only applies to the former, that is pre-publication. They recommend that section 37.1 should be amended to make it clear that the exemption protection applies both to pre-publication and post-publication. And the proposal that they've made is that the clause 37.1 be amended to read personal data which are processed only for the special purposes are exempt, both pre-publication and post-publication, from the provision specified in subsection 2.
Lumping journalism, art, and literary purposes into one defined term, I'm not sure is appropriate, because the constitutional guarantees that relate to the journalistic profession in relation to freedom of speech and expression and so on, the considerations around that are not the same as apply to art generally or literature generally, because there's a different public interest purpose served by the media to artists generally. So although art is protected by rights of free expression, the considerations that attach to the content of the right and the ramifications of the right in relation to the media are more extensive and more developed and more critical to a democracy. So to lump them all together in this way, and then deal with what exemptions are from personal data being processed for special purposes, I don't think was an appropriate approach to the matter.
Our review, though, of the various jurisdictions demonstrate that the approach taken is to actually lump them together, because while while the Constitution gives us that freedom of expression and freedom of speech, the fact is that the nature of the work that they do is not necessarily dissimilar from the nature of the work and the liberties, I'm going to use that loosely, liberties that someone who is using data for artistic purpose or literary purposes might use. And so what it does simply is to say that in these circumstances, we're saying that you are exempt from certain standards. In fact, what this section goes on to do is to give all these three purposes, journalism, literary, and artistic purposes, wide exemptions from the provision in the Data Protection Act. In fact, they are exempt from, if we look at subsection 2, those three areas are exempt from all the data protection standards, save and except standard 7, which treats with how a data controller ensures that there are proper operational measures in place to protect the data from unauthorized access, etc. So that standard continues to apply to them, but they are exempt from every other standard. They're also exempted from Section 6. Section 6 is the right to access section. Section 10, which treats with the right to prevent processing likely to cause damage, as well as Section 12 and parts of 13, which speak about rectification or inaccuracies. So essentially what that provision is doing, that clause is doing, is saying that in these areas where there are certain liberties that will be taken, certainly from a literary or artistic, liberties that might be taken by a writer or an artist, that they're not bound by the standards of the Data Protection Act, in save and except just one, in doing the work that they're doing. So we don't necessarily think that they need to be separated. It's treating with broadly those three areas in which persons are free to write, draw, as the case might be, and anything else in a literary or artistic field without being constrained by the Data Protection Act and a data subject implying by any means that their information is used in a way that, or challenge the way in which the data subject information might be used.
But you're giving such a broad exemption from all of these standards except one to art generally. And I'm just thinking the considerations which would justify the exemption in relation to the media and the role of the media is somewhat different, I think, to the situation of the inherent right of, or the constitutional right of freedom of expression that's given to artists as such. So I don't know, it just seems an odd formulation and approach to take. But in relation to the request to remove the word only, would the inference of that be that if it had anything to do with a special purpose, that would be, even the most tenuous connection would be sufficient for the exemptions to apply? And is that, if you're going to remove only, maybe you ought to have some, substantial connection anyway. If perhaps it doesn't have to be exclusively for a special purpose, but it ought to have a substantial connection with the special purpose.
So remember, our recommendation is to not delete the word only. Our contention is that if it is that you are going to be exempt from almost the entire legislation, save and except one data, the standard, it is only in relation to your work as a journalist or your work as an artist or your work as a writer. To remove the word only then would leave them, give them a little bit too much leeway to insert or use or rather to use the data subject's data for other purposes, which someone would have to sit and assess whether or not that is directly related or not. So when we say only, we're saying the right, this exemption is given solely for the purpose of doing the work of a journalist, and solely for the purpose of doing the work of an artist or a writer or literary work. We're not leaving it to anybody's imagination about where you're going to be, what you could possibly use to do with it. We're saying you're being given very wide exemptions, and that is only related to one thing, and that one thing is journalism, as the case might be. Literary.
So what is the basis on which they are requesting the removal of that word? What is the concern that they have that word imports?
Well, based on their comment, all they've said is that the allegations that publication is not only for the purpose of journalism could stifle the practice of journalism in a small, closed society. We don't know.
Jurisdictions have treated with it. I know you have the commentary here, but if you could just summarize for us how other jurisdictions have dealt with that issue.
So one of the ones we have is the Canadians and the Protection of Personal Information Act. They state that personal information can be collected without knowledge or consent if the collection is solely for journalistic, artistic, or literary purpose, and then they go on to say what they're exempted from. It doesn't apply to any organization that collects, uses, or discloses personal info for the above special purposes, that is artistic, literary, and journalistic, but it's solely for that purpose. The Privacy Act of Canada does a similar thing. It does not apply to personal information that the Canadian Broadcasting Corporation collects, uses, or discloses, and for these purposes, and does not collect, use, or disclose for any other purpose. So what they're saying is that is the single purpose for which you are utilizing the information. And so solely is used throughout most of the jurisdictions that we have looked at to cauterize, I would say, because at the end of the day, it's an exemption that is fairly wide and seeks to balance. And I think if you look at we would have consulted with the Attorney General's chambers on this. What we're trying to balance here, members, is yes, a right to freedom of speech, but also a right to privacy.
Thank you, Ms. Murray.
It's a pity that they weren't more analytical as to the basis of their request. Because on the face of it, they haven't given any reason whatsoever for requesting the removal of that word. Yeah, but it's an important issue because it's the sort of thing that can go to the constitutionality of the bill. So, if they have a grouse, they ought to really have extrapolated on it so one could understand where they're coming from and see whether it really is worthy or not of being taken on board. But as it stands, we really don't know what's behind the request.
I have a question, though. I'm trying to work through in my mind. And it's not too far from where Mark left off. When we grouping of literary, artistic, and journalistic together, because of the standard, I'm just working through my mind. So there's some information I get on somebody, and I want to go public with it. And it's that I create a dub poem and say this is artistic work and share that information. Am I protected by this provision? I'm not sure.
It could be a really bad poem.
Yeah, exactly. It sounds a little trite, but I'm just trying to figure how do you really define. In everyday work, we know artistic and literary work, but how do you really define when somebody's really doing artistic or literary work, as opposed to really trying to, what's what I'm looking for? You understand what I'm saying, Mark?
Yeah.
Share information, so to speak, in a malicious way. It's not satirical or anything, just trying to share, or for political purpose.
Propagandists. We have a few of them around.
Yeah, I think perhaps that's the word I'm looking for. I just wondered, and perhaps you could help us by telling us how. I know you went about how other countries treat with it, but if there are any real life examples that comes to mind. And I'm coming. Exactly. And then it's not too far from what Mark said, because I believe that the standard for journalism, should be very different from the standard for the literary and the artistic material. And by grouping them together, and because anyone can get up tomorrow and say, I'm a dub poet, or I'm a writer, and put whatever they want, how do you define someone who is genuinely expressing for artistic purpose?
Okay. And in that, Ms. Murray, as you answer that,
Thank you, Chairman. I'm going to give a little bit of an explanation, but I'm going to ask for some time, perhaps to the next meeting, for us at the AG's chambers to do a little research. I am not sure that the standard should be different. We're looking at the same, right? And in fact, we were going to also suggest that the committee consider in 37(1)(b) referencing not just the public interest in freedom of expression, but also referencing the right that is in 13(3)(d) of the Constitution. So freedom of expression is 13(3)(c). 13(3)(d) gives you the right to seek, receive, distribute, or disseminate information, opinions, and ideas through any media. That is also relevant here. And so we were going to ask for that to be included and incorporated. It's not just a freedom of expression issue. The fact that we are looking at both those rights in relation to not just journalists, but persons who are doing literary, artistic matters, I'm not sure that the standard would be different for just because I'm an artist compared to because I'm a journalist. Because it is true that the reason you're you're protecting the work of the journalist may be slightly different than that of an artist. Both are still very important. Both serve a certain type of purpose in a free and democratic society. So we would like to have just a little bit of time to just see if we can find any case law that can give us any guidance, especially as it comes to maybe the standard and burden, because I'm not sure that, thinking about it, I'm not sure that we could justify and say one is at a higher standard than the other. And if we can't say that definitively, then I'm not sure it would be correct to even say split them out, because if you're splitting them out, it means you think that one should be afforded more protection than another. So that's the comment right now, and then we're just asking if we can have some time to do a little research, and then perhaps we would be able to, not perhaps, we would then be able to be a little more definitive on the topic at the next meeting.
What about this one? I think we should be very careful, because historically, journalism, literature, and art on many occasions commingle. Art in terms of caricatures, art in terms of paintings which are commentary on society. We saw that in the French Revolution, we saw it in other situations. Literature, just the same, where literature has been a commentary on political actions and activities and the status of society through satire and through other mechanisms. So if you go to the artistic community and have a conversation, they, in many cases, will associate their work, political art, as requiring the same level of freedoms and protection as journalists would get, and even artists as well. So I, for one, don't see the necessity for a separation, as while in our society, colloquially, we may see journalism as being of a higher order in terms of the freedoms that it is accorded. I would suggest that those who practice their commentary through literature, those who use the written word, the spoken word, paint on canvas and whatever implements they use, would also contend that their rights are similar to those of people who practice journalism.
So, member, the AGC has asked for some time to take a look at clause 37 and consider. Right.
Yeah, Chair,
So
I just want to make one point though, which is that while I'm not seeking to advocate for any hierarchy in terms of importance or worth of protection, I think the purpose of journalism in a democratic society and the media as the outlet through which journalism is practiced is very different to that of art. I accept fully that some art is political, some art is strident, but it's ultimately through an artistic appreciation of the work that you get that. Journalism doesn't have that element to it. Journalism is about dissemination of ideas and opinions. The particular paragraph that was read, primarily that's its primary purpose, and it's acknowledged in case law and so on, the importance that the media plays in ensuring freedoms are protected in the society. And art does that too, but it is not the primary purpose of art, and it's not the primary effect of art, and it's not central to the way in which a democratic society functions on a day-to-day basis. So to me, they're quite different. I think it's unrealistic to posit otherwise.
Can I?
Chair, certainly I think that the proposal that has been made by the Solicitor General would resolve a lot of the concerns that we have, because we can see from the case law what sort of approach has been taken to these rights.
All right.
Chair, if I might, through you, just to inform, and I yield to the SG and note what the SG had said in relation to the research that is going to be done, but I think it might be useful for us to understand what the is, if it is that the concern is that when the clause, when read, and the exemptions that have been given should be afforded to journalism, but not afforded to literature and artistic purposes, or literary and artistic purposes. And I think we need to understand that, because while it is, I hear the concern about lumping the three together, what I'm taking from that is that we're saying that the wide exemptions that have been afforded, all three, may not be necessary, and the exemptions might be applicable to one vis-a-vis the other two. And I want us to be clear so that we can, at least when doing the research and doing the further work, understand the position of the committee in relation to exactly what.
I think the deprivation of privacy rights, which is inherent in the structure and the exemptions that are being given, that deprivation of privacy rights is capable, I think, of being abused if the exemption is too widely couched. And as Senator Fraser-Binns indicated, the concept of art is extremely wide, and where the boundaries of what is art and what isn't lie is not easy to define. And one could see where it could be the subject of abuse if persons wanted to utilize that exemption for their own purposes in a way that would be damaging to data subjects.
I wonder, I don't know if there is consensus as to any idea that there needs to be any approach in how we frame this thing that could be construed that it is a fetter on persons' ability to express opinions through literary works or through artistic works. I don't know if I would want to be associated with that sort of approach, because then you're going to start going to definitions. How are you going to define?
How do you categorize?
How are you going to separate the commingling between what some artists may consider their form of journalism versus what may be an attempt to strictly define what journalism is? I think that that's a rabbit hole that I don't know if it is necessary to sojourn.
All right, thank you, committee members, for all the contributions. We will hear back from SG next meeting or the next one with regards to this particular clause 37. All right, we'll move on to clause 38, and this deals with research, history, and statistics with regards to whatever exemptions are available here. Ms. Murray?
Chair, there were no comments from stakeholders in relation to clause 38.
I put clause 38 to committee members. Approved. We'll move on to clause 39, temporary exemption for manual data held by public authorities.
So members will recall that there was a recommendation, well, in its examination of clause 9, that concerns were raised by Flo and the Lawyers Christian Fellowship about government's exemption. And this particular clause treats with government exemption from manual data, which is held by the public authorities. The ministry is recommending that this clause be deleted and removed to the transitional provisions under the legislation along with clause 9, that the period of exemption for manual records be extended to both public and private sector to give everybody the same. Well, let me step back a little bit. That the period exemption for manual records be reduced to 18 months. We have here now 2 years, but that it would be applicable to both public and private sector to give all data controllers within the public and the private sector an opportunity to have their manual files in order to comply with the legislation and to give effect to rights such as access rights and so on. So this was just to give, essentially to give public authorities that have heavy manual filing system an opportunity to have those filing systems brought up to date and treated with
it from 2 years to 18 months then.
We're proposing a reduction. We thought a year and a half might be enough for a transitional period.
And if it isn't, can it be extended? Or you have to come back to Parliament with an amending bill?
We probably would have.
Fixed periods of time when you don't even know how much work is involved and what resources are available to allocate to that work is a dangerous way of proceeding.
We would have considered that there is work being done now by public bodies to digitize records, etc. So it's not, it's some, right? There is work being done, and we would have And
I think a part of the challenge is that.
So we have no objection, though, and we really. That's yeah.
I don't understand why the exemption. Why do we need to give an exemption at all? I mean, you mentioned that work is being done. We have no, but we know from at least 2 years now. We know about this thing coming into effect. Why are we giving an exemption? We just need. I mean, you guys already got the money. Use it and bring the thing up to standard by the time this come into being. And I'm saying that with a very straight
yes.
Violators from day one.
Right. And then we know for a fact, I mean, that there are ministries, and I'll just use ministries, that have thousands and 10,000s of files, and those are personal files that they're trying to get in order. So we would want to put yes, but we don't even no, let me not
Campaign yet.
I mean,
Use some of the money that you guys left and didn't use.
remember, I think part of the challenge.
If we're serious about this, to have it done.
I think part of the challenge is that, and I agree with you, that this thing needs to be done very quickly. And I think no one here would not associate themselves with your position. However, the reality of it is that it is not only an issue of financing based on where I've sat and seen information, it's also an issue of personnel and persons who can be authorized to access certain types of documents too. Because these, we're talking about data protection. A lot of this information is, some of it held in hospitals, people's personal medical records, clinics, the courts, and so on. So this is very sensitive data that you cannot just get some hope interns to just go into a hospital to start digitizing documents. It has to be held in a particular way, or else you'll expose the entity to particular liabilities. So while I personally, and I'm sure other people here would agree with you, the reality is the reality.
And you know, Senator, I understand. I mean, having worked in a public service, I can appreciate the challenge. But what I'm saying is that we have been doing this for so long. This bill has been before this committee for at least 3 years, if not more. And we're still where we are. So I'm just not convinced that 2 years is going to make a difference. I just think that we just need to deal with the issue and deal with it now. And if we were really serious, then we would have done what is required. We would have, because we anticipated that this bill would have been passed at least a year ago. And we're still where we are, and the improvements or that which is required to make them compliant have not been done. I don't know if passing the law is going to make them compliant, but you know what? I can be convinced.
Just to give a little context, so Trinidad and Tobago passed their law 2011. And they haven't implemented most of it yet. It's just a little bit of context. When we are thinking about the agencies that have these types of records, think about an accountant general, think about administrator general, even the attorney general's department. A lot of us are already in the process of trying to do things like digitize, and that is ongoing. But it is intensely heavy on the labor side, the human resource side. So it's, as Senator said, it's not just even the literal money. And already a lot of these ministries, departments, agencies are stretched. We are moving ahead, and I know this from my interaction with MDAs and the ATI Act and the ATI Appeal Tribunal. We are not where we were a year ago in terms of ensuring that we have proper classification of all our records and keeping them and storing them. We are in the process of improvement. I think it would be good to give us, government, the time to try and go ahead of the game, because I really would not like us to pass a law and at least how many of us would be automatically in breach of statutory duty.
My last comment, Chairman, is I'm not convinced, and if I'm supposed to accept what the Solicitor General said, then perhaps we should give 5 years. And I'm not saying that with any water in my mouth, we probably should give 5 years. That's one. Secondly, perhaps, and I don't know if it's in the bill, and I have not seen it, but if we're considering given some time to the government, then we should also give time to the private sector, particularly small and medium size, if it's not there. So that's what I'm saying. And I wouldn't go for 2 years. I'd go for 5 years, because I don't think that we're going to get anywhere in 2 years.
I might just add to what SG has said. The Ministry of Education, Youth and Information, last year I think it was, implemented their records and information management policy. And they are actively, I know, working with ministries in particular to try to give effect to that policy. They're heavily engaged with the Jamaica Archives and Records Department. Right. No, so I'm not suggesting 5 years. We think that 2 years would give, with the work that is being done now in relation to that particular policy, 2 years from this particular legislation coming into force, we think that that should give all of us, both public and private, enough time to have our information streamlined. One of the things that we're trying to do is what we really are trying to avoid is a situation where a data subject or any Jamaican goes to any of these, let's say a health center or a hospital or whatever, and when they are seeking to access their rights under the legislation, they're told your file can't be found, or I have to go and, so. Right. So we're trying to say, and what the signal will be is that you need to get your filing system in order, and you need to automate to the extent that you need to automate if that's where you want to go, maybe because of the volume, but that it must be in a state that when a data subject comes and requests information in relation to themselves, that information can be readily available. And then you're not telling the data subject that it's going to take you 2 years to find information in relation to them. And that's what we're really trying to do. So we're giving time for both, and the proposed amendment, member, is that this be applicable to both public and private, to the extent that there may be private data controllers that are in a similar position that some government entities are, rather.
Ms. Murray.
Do you have an idea as to the timeline for implementation of this bill? For when it will come into effect?
As soon as we're completed with this, as soon as we're completed with this process.
Yes, and then you'll send it, and once it's passed, then you'll see the assent of the Governor General.
Okay. Well, what was, if I might, in response, what the current version of the bill that we're considering recommended and implement a transitional period of a year. Almost all the stakeholders that would have engaged the committee said that time was too short. And so what is recommended to the committee, even though we're not there at that section yet, is at least 2 years. Right. So even if the bill is passed before, hopefully, the end of this legislative year, then we would be saying that within another 2 years from then, and it could be, and we could ensure that's inclusive as opposed to, right. So it's 2 years that we're contemplating before the law would begin to take effect. So because outside of these manual issues, then all data controllers would need to be getting ready in any event so that they can comply with the provisions of the legislation, generally.
Forgive me. So the proposal that was accepted by the stakeholders is that the bill having been passed, that you'll have a 2-year transitional period from the date of commencement, because once the Governor General has sent, it is a minister who brings it, who states the commencement date.
Yeah.
Yes. On
Clause 1.
Yes.
Or 2, whatever it is. 1, I think.
So some provisions are going to come in before. Okay, it's going to come in on a. Oh, I see. That's the idea.
Before what?
What we're contemplating is that portions of the legislation come into effect before others. So, for example, we would need the portion in relation to the Information Commissioner to come into force before the rest of the legislation, so that we can establish the commissioner, and then the commissioner can begin to work with data controllers to prepare them for the full application of the law.
Ms. Murray, could you speak to the comment from Denton Phillips? He thought that there should be a requirement for entities to outline via a roadmap how they plan to go forward in terms of, those entities that have the exemption. What is their roadmap going forward in terms of ensuring that they meet that time frame?
Well, we wouldn't certainly want persons to be having to submit to a commissioner a roadmap on how they're going to get themselves compliant in relation to this. But one of the things we did point out that one of the things that they will be required to do is to submit a data protection impact assessment report. So in that report, they would be giving an update on what it is that they're doing, where they are, what the potential risk is in relation to the data that they have, and how they plan to mitigate. That's essentially what the impact assessment report would do. So in relation to, and I just want to step back a little bit, we're not saying that persons cannot hold or have a manual filing system. That's not what this is about. It's just that we're giving them time to organize those systems. And for those who want to migrate from manual to an automated, then they have the time to do that. But we're not suggesting by any stretch of the imagination that everybody needs to automate. We're just saying that your manual filing system must be in a state of readiness for when the full provisions of the law come into force. So no, the timelines are, you have 2 years to get your manual filing system in order or converted to an automated system.
All right, thank you, Ms. Murray. All right, I put clause 39 to members. If there are no objections,
with the single amendment to the 24 months.
I was going to ask that question. Yes.
Okay.
The recommendation before the committee from the ministry is 1, that the clause be deleted and removed to the transitional provision section of the legislation, that the period we're now saying be extended to when that period be 24 months, and that the exemption is applicable to both public and private.
Sorry, the exemption, here it says, well, we're keeping it at 2 years? Okay. All right, I put clause 39 to members with the 3 amendments as outlined.
Okay.
If there are no objections, we accept clause 39 and move on to clause 40. information available to the public by or under any enactment.
Members, there were no comments on clause 40 from our stakeholders.
Okay, I put clause 40 to members. If there are no objections, we accept clause 40. Move on to clause 41, disclosures required by law or made in connection with legal proceedings, etc.
No comments on 41 from our stakeholders either.
I put clause 41 to members. If there are no objections, we accept clause 41. We'll move on to clause 42, parliamentary privilege.
Members, there was one. There was only one comment in relation to this. It's from Roots. The comment was that more information is needed on what parliamentary privilege entails. The question was asked, well, does this mean that the Act does not apply to members of Parliament? What if a member of the House chooses to search and abuse personal records while sitting in their constituency office or their bedrooms? Right, and which is so that was right. So the response from the ministry was more along the line of a clarification that the exemption applies to members of Parliament while engaged in a parliamentary process in either house of the Parliament, and would not.
This is not just dealing with privilege in relation to defamation, though. I think it's a broader concept, isn't it? It's to do with, for example, committees being able to get information for the purposes of the committee's work and that sort of thing. There's a statute dealing with the immunities of Parliament, which includes even rights to subpoena information and that sort of thing. Yeah.
I understand. Yes, member. Because it does say avoiding an infringement of privileges of either of the hosts.
All right, I put clause 42, parliamentary privilege, to the members. If there are no objections, we accept clause 42. Move on to clause 43, domestic purposes.
We have one comment from the Jamaica Computer Society, JITSA. Their comment was that consistent with the EU approach, it would have been good to clarify that charitable purposes are not excluded. Processing by charities does not constitute domestic use, and so they should be captured by the provisions of the bill. Their suggestion seems to be that the bill should specifically say that charities are not excluded from the data protection. We don't agree that there needs to be that exemption. There are data controllers to the extent that they collect personal data and process that data. So they would be caught by and would be required to comply with the Data Protection Act. No, it doesn't fall within the definition of what domestic purpose is, which is personal, family, or household use.
I put clause 43 to members. There are no exemptions. We accept clause 43. Move on to clause 44, miscellaneous exemptions, and I think we have to read this in conjunction with the second schedule. Yep.
So clause 44 through the second schedule, exempts certain provisions from the Act and the specific areas of the Act. We have two comments, one from the Jamaica Bankers Association. They believe that they commented that the clause permits miscellaneous exceptions to be set out in the second schedule. They were requesting on behalf of deposit-taking institutions the same consideration. The request is that financial institutions or a definition of financial records, including account details, balances on account numbers, transactions, and patterns of transactions should be included in the miscellaneous exemptions outlined in the second schedule. The ministry doesn't support the recommendation. I think one of the things that we continue to remind others and members that the Data Protection Act relates to personal data, the extent to which it can identify an individual. And if we look at some of the things that they would want to be included in an exemption, for example, by themselves without actual personal data, you wouldn't be able to use this to identify anyone. So if I look at those transaction patterns without knowing who it is related to, I can't use a transaction pattern, for example, to determine that that is John Brown or this is Mary Jane. So our view is that the Data Protection Act is intended to protect people's personal data and to ensure that they are only processed by those authorized to do so. So to agree with the Jamaica Bankers Association would mean that the rights afforded data subjects under the Data Protection Act and the responsibilities imposed on data controllers would not be applicable to financial records here to the extent that they are not personal data unless it is that they are actually, you can use the information to along with something else to identify the person. But our contention is that if they're placed in exemption, it means that they would be exempted from the legislation and can't exempt that type of data from the legislation at all.
I mean, maybe because there's an exemption for corporate finance services, so they may feel, why are corporate finance services exempt and not banking services? But banking services are already subject to secrecy obligations under the Banking Services Act. So data, confidential information about a person's accounts are subject to those requirements already, and it's a criminal offense to divulge those. That doesn't exist in the same way in relation to securities dealers. I'm just wondering why corporate finance services made it into the second schedule as the only financial service that did. I wasn't sure what the thinking was, but
So at the in the second schedule, where it speaks to corporate finance and services, you'll notice what the specific exemption is. The exemption is from data subject requirements. Members will recall that that particular terminology is defined and really speaks to information about the data controller specifically, and what it is that, and how it is that the data controller is processing, and to the individuals to whom information, the personal data will be or could be transferred. And of course, the included in the data subject requirement is the exclusion of the right to access information, for the data subject to access information about him or herself. So if it is that we include, or we're minded to include financial records, what we're saying to data subjects is that a bank can refuse to give you information about yourself in relation to your own records and accounts.
Chair, just for CPC, the definition of disclosure to data subject requirements, which is found on page 45 at the beginning of part 5. I was kind of hunting it, took me a while to find it, and I see there's a reference to it in the second that phrase is used in the second schedule. I don't know where else. I'm just wondering whether it might not be useful to move the definition to the general definition clause, since it's being used in different places.
Well, there's no difficulty. We don't have a difficulty doing that. But technically, because it's a reference to the second schedule, which is tied to this part, it's not really. It is covered. But we don't have an objection to moving it.
The reason why corporate finance services provided by a relevant person, which is a licensee, is exempt, is personal data process. The data is exempt. Could affect the price of an instrument. Boy, it's Greek.
I know we're going to come back to the schedules, right? But I put clause
defined on page 97 of the bill at, what's this now? Subparagraph 3, so that's 6, subparagraph 3. So in this paragraph, corporate finance services means a service consisting in underwriting, and then it goes on.
In a very succinct nutshell, just explain to me what's exempt by this paragraph 6. Because it's a series of definitions that push you into other definitions that push you. It's like a definitions chase.
So, in the second schedule, paragraph 6 exempts corporate finance service, which is defined, from the disclosure to data subject requirements in any case to data subject requirements. Let's leave it at that. And then when we turn to page 45 of the bill, so it's, CPC is reminding me that it's not an absolute exclusion or exemption. But what it essentially exempts from is the information mentioned in section 22.6. And if we look at section 22.6, which is on page 34, it says they don't have to identify themselves as a data controller. They don't have to identify who their data protection officer is. They don't have to identify the purpose or purposes to which they're for the processing. They don't have to identify to the data subject a third party potentially to whom the data might be transferred. They don't have to indicate the legal authority for seeking the data. So that is what, and of course, and then it goes on back at page 45, it it also includes the exemption from Section 6, which is the access right. So essentially what they're saying is that with respect to corporate finance service, there is no obligation on the data controller to provide the data subject with information regarding the data controller, about the data controller, and the purpose or purposes to which they're going to be utilizing the data subject's personal information, nor do they have to give them access to the data. That's essentially what the exemption from the data subject requirement is.
This came from another jurisdiction, this particular exemption? You think?
It would have been the UK.
Why though? I don't understand the reasoning, the thinking behind it. I would really appreciate that explanation.
If I may, if you look at in the second schedule at the same paragraph 6, the exemption is only to the extent that the complying with the disclosure requirements would affect the price of any instrument which is already in existence or is to be created. And then if you look at the type of instruments, it means transferable securities, money market instruments, units in a collective investment schemes, options, futures, swaps, and so on. So they're basically trying to protect disclosures that would compromise the prices of stocks and so on.
I understood from the explanation a while ago is that if the data subject could know the reason why it was being utilized, not the so in those circumstances, I want to understand the connection between all of that, the instruments and so on, and the data subject, why it is that the data subject would therefore be denied any information as to the use, because you wouldn't get the details. You wouldn't get to say, I've used your thing to calculate so that I can, whatever. But I just want to, there's a gap in my mind.
Hard to imagine a real life.
I'm not an expert on how the stock market works, but I think what was contemplated is that just maybe the mere fact that the entity is considering certain things might actually lead, if persons knew this, would lead them to speculate and maybe create some disruption in the market.
Just that the type of activities that are injurious to capital markets are supposed to be, and I believe already are, in the securities legislation. That's where they kind of belong, and they're balanced in a particular way to meet disclosure requirements versus market protection and so on. So to have it this kind of looking to do something similar but through this rather obscure route, but if it came from somewhere else, they may have had a reason for putting it in.
Ms. Grant, did you want to make an intervention?
No, Chair. I was just speculating that there would be no harm in leaving it, even if it's protected elsewhere, just to avoid any doubt as to whether this piece of legislation would allow a disclosure that wouldn't otherwise be allowed under another act.
I'm sure the reason why the bankers are asking for it to be in there, for them, is because the securities dealers are in there. As it begs the question, why is the information for that segment of the industry treated differently? But anyway.
All right. I put clause 44 to members.
One last
45.
thing, Chair. There was a comment from FID and they too were seeking exemption on the second schedule. But we would have discussed this before and would have shared that we think that the FID would be covered by virtue of clauses 34 and or 36 of the legislation, so they would not need to be included in the second schedule. But we still have that conversation that we need to have with them in relation to their comments.
Just in relation to the FID though, and on the POCA and so on, the rules against tipping off and all this kind of thing, information in that very sensitive area of law enforcement is particularly crucial. So I think we have to be very sure that we're not going to compromise their ability to do their jobs properly. I mean, in a sense, the considerations around their activities are more weighty than some of the other things that I see listed in the second schedule.
Hence the reason for the discussion, because if we look back at 34, it does speak to prevention and detection of crime and apprehension and prosecution of offenders, and the fact that those are exempt, they would be exempted from the standards from Section 6, which is the data subject access right, as well as the first data protection standard, which says that information must be fairly and lawfully processed. So
the second schedule exemption broader?
No, it isn't. The exemption is as determined within the schedule itself. So different things have different exemptions. So the one that we just read about the corporate finance service, for example, would have exempted from data subject requirements. But if we look at something else, for example, personal data process for the purposes of assessing judicial office or conferring honors, well, that one is from disclosure to data subject. Let me find another general one. But the idea behind the exemptions in the schedule is to exempt specific things from specific aspects of the legislation, not necessarily to the entire legislation, but to certain parts.
How was the second schedule amended? There's no general provision for amending schedules.
Right,
No.
so it would have to come back to the Houses as an amendment to the Act itself.
Is that desirable?
I would say yes. What I think the Parliament certainly would want to be aware of is, in relation to a legislation like this, is what, if any, amendments can be made there too, exempting certain persons or data controllers without knowledge of it and being able to opine on it. I think it rises to the level where amendments to exempt anyone really an amendment to the legislation should come back to Parliament for the consideration of the Houses. Because otherwise, you'll have a single, that's right.
Thank you, Ms. Murray. I put clause 44 again to the members. And if there are no objections, we move on to clause 45, which is the power to make further exemptions by order.
There were no comments on clause 45.
I put clause 45 to members. There are no objections. We move on to clause 46, and which begins part 6, enforcement.
Yeah, just to note that the schedule can effectively be amended because 45 allows the minister by order to grant exemptions. So in effect, the categorization of miscellaneous exemptions can be increased by the minister. And that's not subject to affirmative resolution or anything.
The power in 45 doesn't relate to the second schedule. It relates to a more limited power to exempt where the personal data consists of information, the disclosure which is prohibited or restricted by or under any enactment, if and to the extent that the minister considers it necessary for safeguarding the interests of the data subjects or the rights and freedoms of the individual.
Well, except it doesn't make reference to the second schedule, but isn't the second schedule a sort of potpourri of different miscellaneous exemptions, and the different people are exempt from different things in the second schedule? So in a way, this allows the minister to grant other exemptions that might have been included in the second schedule originally, but weren't or ought to have been, or is it not? Is a type of exemption that 45 is dealing with very different in character to what the exemptions in the second schedule are dealing with?
Yes, the disclosure would have had to be prohibited or restricted by another law.
Okay. I put clause 45 again to members. If there are no objections, we accept clause 45. Move on to clause 46.
So clause 46 commences part 6 on enforcement. We have 2 comments. Technically, yes, 2 comments, one from Credit Info and one from Flow in relation to clause 46. Credit Info expressed a concern with the fact that enforcement provisions are introducing new standard of compliance to which the Credit Bureau are not subjected to under the Credit Reporting Act. These provisions will pose a conflict between the powers of the Bank of Jamaica supervising authority and the commissioner. They know that the BOJ is, of course, responsible for the oversight of the licensing of credit bureaus, and therefore give ongoing oversight. I think essentially their point is that this is just an additional layer of regulation for them in light of the role that the BOJ plays in overseeing their activities. At clause, as it relates to clause 46.3, they note as well that the commissioner has the power to issue an enforcement notice on the basis that a breach of the act is likely to cause or caused an individual damage or distress. The damage or distress is highly subjective, and there are no set criteria for making such a determination as to whether an action will or has caused damage or distress. And then the concern from Flow is that essentially that the enforcement regime seems elaborate and will be an added cost to businesses. Our comment from the ministry is that yes, we agree that the DPP, the Data Protection Bill rather, is introducing a new regime for financial institutions and other businesses, but we do not agree that the enforcement scheme proposed is too elaborate or that, in general, the provisions pose a conflict with supervisory role of other regulators. With respect to the credit info's comment on the language likely to cause or cause an individual damage or distress, the committee is asked to recall comments by stakeholders on the subjectivity of the term distress and is directed to our research finding in relation to clause 10. That's where we would have dealt with this in a little bit more detail. Essentially, the findings were that all jurisdictions addressed or use the term likely to cause damage or distress without providing any definition for the term.
Okay, members, we're asking for approval of clause 46 to 57. Oh, sorry, clause 46. Sorry, there's a 57 on my paper here. Clause 46. Approval? Okay.
Thank you, Member Cuthbert. We'll pick up on clause 47 now.
We had a number of comments on clause 47, and clause 47 relates to the need for data controllers to prepare an annual data protection impact assessment report. The Jamaica Bankers Association noted that the form of the DPIA will dictate the information which is collected and analyzed. As a form will be published in the Gazette, this clause should not come into force until 1 calendar year after the publishing of the form in order to allow data controllers to collect appropriate information. They suggest a phased implementation of the Act, with this clause coming into force a minimum of a year after the relevant forms are published in the Gazette. The slash roots in relation to clause 47.1, the proposal from them is essentially that there be a tiered application in relation to the need to prepare the data protection impact assessment report.
What's the threshold for this?
There isn't any.
There's none?
No.
So every firm that has personal data or organization going to have to do this?
Would be required to do a... Yeah. So the concern here is that we would be requiring small and medium-sized companies to report, which might be onerous.
What we do is have a huge pile of that data piling up in the commissioner's office. How many thousands of data controllers are there in Jamaica?
Question. What was the, in light of what the member just said, what was the rationale for putting in this requirement on everybody?
Well, one of the standards that data controllers will have to adhere to is the 7th standard, and the 7th standard speaks to the need to have appropriate technical and organizational measures implemented to ensure or to guard against unauthorized and unlawful processing and access to data. So essentially, what the data impact assessment does is force the organization to review its internal processes to ensure compliance with the legislation and to guard against risk. So it really is saying to them, to the extent that you are processing personal data, which might include sensitive personal data, you have to identify the risk of loss or breach or unauthorized, and you are to then mitigate against that. So the intent of the impact assessment is to have the data controllers do an internal assessment of their systems and whether or not that their systems comply broadly with the legislation, and then of course offer the protection that is required for data subjects in terms of breaches. And once they've identified those risks, to indicate in that same report how it is that they're going to be mitigating against those risks. And that report is something that they would file with the commissioner, and the commissioner would have an opportunity to review same and to determine and make recommendations as to areas that they may want to strengthen.
You have to register with the commissioner, right? So I think we went through that. So why don't let the commissioner determine who he wants these things from on the basis of them proposing a particular risk based on their size or whatever? I mean, why not having a more risk-based or more nuanced approach, and as every data controller has to do? Because this is not going to happen. I mean, most MSMEs aren't even keeping proper accounting records, much less to go produce an evaluation of how they manage their data of the previous year. It's just not going to happen.
I was going to ask you what the penalty for non-compliance is, and what the commissioner can do based on his or her own assessment is choose companies, do random audits to make a determination of the risk based on the profile of companies. But you're really just putting in a clause which is going to be observed in the breach.
Isn't there something to be said, though, for the early days of this legislation in terms of the commissioner wanting to know this information, and then maybe as they go along you have the situation like Member Robinson is describing, where you do spot checks?
I don't think there's an objection necessarily with a tiered approach and or the Information Commissioner determining what class of, what class of data controllers would be required to do an impact assessment based on the nature of the processing that is done. The chair did mention something, and it's something that we have in our recommendations to the committee, that in the first couple of years of this legislation, what we really are trying to do as well is to get data controllers in a data protection mindset. And so for the first several years, we are pushing compliance and wanting to have, and even though we hear the comments about who will not be in compliance, but generally a clause that get provisions within the legislation that have everybody moving to a particular standard and not feeling as if, because this doesn't apply to me, I can, be as free as I want and as loose as I want with people's personal information or personal data. What we're really trying to do is to build a culture in the first several years, and then you can migrate to a more light touch type regulation of data controllers. But as it is now, we have no culture of data. I call it light touch because member, because some persons will be left, if it is that the commissioner, whether through a tiered process or a class or type of processing process, is going to determine who it does not audit or who it audits or who it requires this information. It means that some persons are just not, are unlikely going, it's highly unlikely that some persons will be even asked to do an impact assessment report and will feel that, oh, well, there is no need to. Bearing in mind that because you're small doesn't necessarily mean that you're not processing a large amount of data. So there are those nuances as well. I mean, size doesn't necessarily mean that the processing is small as well.
So it can be a risk-based assessment as to who should do this, and the commissioner who should be well positioned to make that determination. But they have to evaluate the impact assessments that they receive. That's a mandatory requirement imposed on them. And if you have every data controller supposedly complying with this, there's no office that's going to be able to do evaluation on many, many thousands of these assessments that are coming in within 30 days, 90 days of the end of the year. It's just not realistic.
No, I thought the report was supposed to be submitted within 90 days, no?
Yeah, the report is.
Yeah,
so you're going to have a deluge of them within this 90 days, and then they have to do this assessment. Right. Of course, they have no time frame within to do their assessment. They can take 5 years.
Right, but I'd imagine, though, that if they're going to have thousands of reports, they'd have to find some way to automate the process in terms of what it is they're looking for or whatnot. I wouldn't imagine that it would be a manual process to evaluate all of this.
I don't know, maybe some brilliant AI program will become that, enable it. I don't know, but, I don't see many of our corner churches and NGOs and small shops and, where people have credit files on their customers, I don't know. To me, we need to, the approach is wrong to just require everybody to do it. It should be more let the commissioner decide what categories, classes, or specific controllers. I wouldn't, they should be able to do that.
But if you don't have the information to begin with, I don't know how you can make that decision, though. You know what I mean? I'm more in agreement. I'm more in agreement with having everyone submit in the early days to develop that culture, and then you migrate to doing a risk assessment. Not requiring everyone, but just saying who is most at risk of not complying.
Is there a penalty for not doing this? I haven't yet found what the breach of Section 47 deals with, because Section 54 doesn't seem to cover it. I don't know. But, Minister, they're just not going to do it. This thing about everybody doing this, it's not going to happen. And it's, I think, unreasonable to expect people to do it who have very small organizations with very limited staff and poor record keeping.
And the cost implication, and especially, if there is a thinking that you want to have a hard touch and then a soft touch, because small businesses would have expended money in the short term to comply, only to find out 5 or 6 years later that they don't have to comply because the government is now taking a softer touch. And I wondered, Minister, whether there is any consideration for whether it's going to be tax incentive or some incentive, I don't know, that the government is going to provide to these small businesses who now have to expend money to comply. Take, for example, my place, where I order my weekend dinner and lunch from. They're now going to have to put in place at least one person to comply with the act, which is going to be a cost. And I just think it is unreasonable and unfair for the government to ask those businesses to take on that additional cost. Perhaps the better way is to start with the larger companies. And how do we determine that? You could start with that because of the threshold. I mean, you already have increased the GCT threshold. You could start with that as a way of determining the companies that you want to target, and then you work down from there. So you give the small and medium-sized enterprises an opportunity to become compliant over time without the penalty. Or if it is that having done your assessment, you realize that you only need to focus on the larger entities, then that is the case. But I just do not believe that it should be implemented and required by all MSMEs in the initial stages.
I have a
Remember,
question.
two things to note.
So I'll relate a story, and this is probably a large company. I won't call their names. Many years ago, I went to this remittance entity, and they asked me for everything: my home address, what do I do for a living, my source of funds, who am I sending the money to, what's the relationship, all of that. And there have been other situations where small companies have asked for similar information, just like the large companies, that can impact the individual data subject, where if that information is handled in a particular way, can have a disastrous impact on their privacy and their ability to do business. So I'm very challenged in, while I understand the need to ensure that we do not put in place something that is going to destroy small businesses, the impact that a breach in a small business has on an individual is similar to the impact in many cases that a breach has on a large business. So I don't know if moving the conversation from the side of, because they're small businesses, they should be exempt from certain responsibilities, is a reasoning that is going to solve the problem that this bill is seeking to address.
I agree. It's not about them. It's about the information that they collect on us. And they could be, well, again, somebody raised the point that the company could be small, but they collect a lot of information. And if you look at a credit information company,
so a small
if you look at
bureau.
if you look at their revenues, it might not be huge as, say, a bank, but they collect vast amount of information.
And that is just one consideration, and there are a plethora of things we can consider in determining what companies or what entities should comply. But I don't believe the best practice, I don't believe that for our country, that we should just implement whole scale. We may need to take some time and list some of the considerations to which the Commissioner must address his mind. But, and I will support that. And I understand Robert's situation, but I just don't think that implementing it to every MSNE, every entity is going to. My church, for example, my church has everything on me. I mean, and I can tell my church we can barely afford a secretary 5 days a week. We're not going to ask the church to take on somebody to provide that information is required so we can become compliant. So we need to be very forensic in how we determine to whom it is applicable.
But let me ask you, not to prolong this, but let me ask you, let's assume that one of these small businesses or religious entities, for whatever reason, violates your personal data protection, and you find out that, well, they were not asked to do an assessment, or they were exempted from all. What would you say?
You do your assessment and you determine which entity. It is never going to be 100%, and we can accept that. Because even those that you're going to ask, that you're going to mandate, not ask, that you're going to mandate to provide the information, you're still going to have your breaches. You're still going to have the abuse of information. And so you have to accept that. But at the same time, it has to be a balancing act. And I believe that accepting the need to protect people's information, but also accepting the country in which we exist, requires us to have that kind of balance. And I believe that the Commissioner and the team that he will have will be far better placed to make that balancing exercise.
I don't think it should only be on the basis of turnover, though. I mean, there could be particularly, as you say, sensitive activities that ought to file, even if they're relatively small, you know. And I think the commissioner should be able to sort of identify those professions, for example. You know, members of those professions should file this thing, even if it's a one-man thing, to make sure that they are managing their data properly, regardless of their turnover. But I do think the commissioner should be empowered to determine where those risk categories are and who should be obliged to do this. Because if you just require everybody to do it, it's, you know, it's not going to happen.
Chair, would it be appropriate in light of clearly reasonable arguments on both sides of the issue for you to look back at this clause and do some research and get back to us on what are some of the possible options?
Actually, I have a response now, just waiting. All right, so the GDPR in Article 35 speaks about data protection assessment, impact assessment reports, and they have a similar requirement. They, however, say that where the processing is one that is likely to result, and this is the language they use, is likely to result in a high risk to the rights and freedoms of natural persons, the controller shall, prior to processing, do a data impact assessment. What the GDPR, what they also did was they issued guidelines around the data protection impact assessment. So they have a data protection impact assessment guideline, draft guidelines that were issued, that would have been issued by the EU Article 29 Working Party, and they've outlined what they consider to be data controllers that would fall into this high risk processing, that would be high risk to the rights and freedom of data subjects. And included in their guidelines are, I'm just going to read if the committee will allow me, these are some of the things that they are looking at in terms of the persons who would be required to process. Those that evaluate or score, so any processing that involves evaluation or scoring a data subject, for example, whether it's a credit bureau or so on, and include profiling. So anybody who does any kind of profiling on data subjects would be included and captured under that. Profiling in the sense that you're using the data collecting data on individuals and then using that to push services out, right? Automated decision making, those that are involved in automated decision making, systematic monitoring of individuals. So if you think about systematic monitoring of individuals for organizations, for example, that might use a CCTV or monitor their employees' use of certain things, then that would be covered. Those persons would have to do an impact assessment. Processing of sensitive data, I think we all figured that would fall in there. So that would cover most of our, well, quite a few institutions. Processing data on a large scale, matching or combining data sets, so where that is part of the those are part of the activities. Processing data concerning vulnerable data subjects, and data that is going to then be transferred outside of the jurisdiction. So they've gone on a little further to, through guidelines, define what they mean by or signal those data controllers that would need to do an impact assessment because the processing is high risk to the rights and freedoms of natural persons. So, Minister, in light of the concerns that have been raised by members, it is possible, I think, to amend this clause to give the Information Commissioner the power to determine by order, gazette, notice or order, I don't know, those persons who would be required to, by virtue of a similar kind of listing to do an impact assessment. I mean, it's the GDPR, as I indicated, has a framework that seems along the line where I think members are going.
Could you check the registrar of companies just in terms of guidance on compliance, just to find out like what percentage of the companies do their annual filings, just as an example, to get some guidance in terms. Eh? What percentage are currently there? Yeah, with their filings, just so you can have an idea of what compliance is like in something like this, to get an idea of what it possibly could be. And I mean, that is a lot less, I would say right now, onerous than the imposition of this.
Sure. One last thing on this, though, members, and just to take us back to the conversations that we would have had or would have been having on registration and who needs to register, which is everybody. Because I think, because where we are in the discussion now is that we're saying that some persons ought not to need to do certain things. But if the Information Commissioner is going to be in a position to determine who should or who should not, then I think registration is something that would be required. You can be required to register, but then we will, so it becomes difficult for a determination to be made if we don't even know that you exist.
The same considerations apply for registration. That you might have a general category of persons who must register based on size, and then the ability to the Commission to require others who may not pass that threshold but be considered to be particular risks and require them to register. I mean, I thought that in Europe they've gone away from this mandatory registration thing for everybody in the European directive.
No, they have to some extent, but I think members, we need to remember that they've had like 15 or 20 years of doing this. So they have now their supervisory authorities now having hand a database of every single person that is probably our data controller, so they're at a position where they can determine, we don't need registration anymore. So I think
their economies and societies are, way further ahead in terms of, per capita income and everything else that you're talking about imposing on a lot of our society are struggling on the edge of survival, and small businesses go out of business every day because they have to eat, they have to consume their working capital to send them kids go to school, so it's just a different environment that we're in. I don't think
members, I think if we're serious about having a data protection regime and starting it on the right footing, I am of the opinion that we need the data commissioner would need to collect the information about all the entities by way of registration, and would need to at least, even in the first year, get an assessment from everyone. Beyond that time frame, whatever is determined, then you can begin to do the risk assessment. But if you don't build the database of information, I don't see how you can do that risk assessment and begin to do just this spot check audits of companies.
Chair, I have to fall on the side of the individual, and we have had a laissez-faire approach for decades with people's personal information and how companies use this information, trade this information, small companies, large companies, You see it on your phones every day where your phone numbers have been given out and marketers are sending stuff to you. And it's not just large companies. And I think I have to side on the side of the individual and their right to privacy and their right to own and control their data. If you are going to transact business with people's data, there must be a framework of accountability, and people must know that you are using persons' data. I have to side on that.
Well, I think that the legislation should be pragmatic in its approach to how we address this and allow the criteria for registration to be designed in a way that ensures reasonable levels of compliance, and as you go over time you can expand that and build your database over time. But to force, given what the proliferation of small entities of such an array of types in our society, and we're not just talking about for-profit businesses here, we're talking about any organization or individual who has a file on somebody else. A gym, there you go. Yes, everything. So I think we should crawl, then walk, then run.
Member Currency.
Minister, what I'm hearing here is a balance. Certainly we can't ignore what Member Morgan is saying. That is paramount why we are here in the first place, protecting people's data. But I also like what Member Golding is saying about reasonable levels of compliance. So therefore one certainly cannot obliterate the other or compromise the other. So where Senator Morgan is going, it is paramount to the privacy that we seek to protect, yet at the same time we take certain realities into consideration, as Member Baines was saying, and move ahead with those reasonable levels of compliance. And I think right there is where we may strike that balance.
But the last thing I would say on this is that I cannot hold you compliant if I don't know that you exist. So registration has to be, and how can, even if you register, how do I know the extent of your ability or the extent of your willingness or the extent of your actions in protecting my data? Because even if you're going to look at it from a mass level where, because I'm a large company and I'm processing thousands or tens of thousands of people's data, let's look at it from the individual level, the impact that a data breach or the mishandling of data by a small business can have on a family, can have on an individual, have on a person. And I think that's where I sit. What are we doing to protect the Jamaican individual and their privacy, which has been compromised for so long without any protection, appropriate protection?
Chairman, if I may, because I do appreciate where Member Robert from Clarendon is coming from, because Member Charles and I have spoken, and so I understand. But the thing is, I think we're conflating both issues. We're conflating the issues of the mandatory application of submitting the data and the registration. My position in terms of the first one stands. I don't believe it should be applicable. I believe that Ms. Murray has shared with us some guidelines that the GDPR has considered, which I think are very useful and reasonable, and I would dare recommend could be applicable to our situation. In terms of the issue of registration, I am of the view, and I think she said it, perhaps not for everyone to hear, but it was echoed by Member Morgan, that if you don't exist, how can we decide whether or not you should comply? And my position is I would have no challenge with a registration process for all users of data. But that process should not be one that deters compliance. So it should not be costly, it should not be very involved. It should be something simple, maybe a form you complete and you submit to the commissioner with certain specific information that he then uses to make his determination whether or not that entity should provide the detailed information.
ask you kindly to excuse me because I must go. Thank you. Um, Chair, the point raised by Member Morgan, I don't want to refer to it as a silo. I just want to say it is a massive point where in the whole scheme of things, that point has to be impenetrable because it is the basis on which we are sitting here going through this bill protecting people's personal data. But when I'm thinking about compliance in this issue and for us to be balanced or reasonable as it pertains to set compliance, I'm thinking in terms of cost. That's it. So where it comes to registration and so on, fine. But one would not reasonably expect that the resource that a small entity would be able to expend, I'm not sure if it would be comparable to that as a mogul.
Committee members, I hear all the arguments. I still maintain that we are beginning a new regime in this country. And so I support wholeheartedly registration so we know who is out there collecting the data and what data it is that they're collecting. This particular clause deals with an annual assessment that the data controller has to provide to the commissioner. And again, in the early days of this regime, I am going to say that all entities who are dealing with our personal data should be required to give an assessment. Thereafter, the commissioner can move to using a risk-based assessment, whatever, to streamline the process thereafter. But at the very beginning, I believe that there should be information on everyone as a place from which to begin.
Just to clarify, are we then saying that the risk-based assessment will be after a certain period of time, or are we going to be saying that to people, or how is that going to be done? Because if you tell persons, yes, this is going to be an annual assessment, and then after a period of 2 years, then it's not so. I'm not sure if I want to, if I'm in agreement with something like that. I think if you tell someone that it's an annual assessment, they have enough time to get things in order for that annual assessment.
No, I don't think we're prescribing any time frame. We're just thinking out loud how this could evolve over time, right? It would depend on the controller having gotten annual assessments. And then probably there would have to be an amendment. I don't know if that is just an operational point or, it'd have to come back and be changed. Ms. Mario, would you know that?
So what is here now is a year. It's an annual. It contemplates an annual. So I take the point that if it is that we're going to consider at some stage the commissioner determining who doesn't need to, then I think, this is what I'm thinking, we would have to have provisions within this to be able to enable the commissioner to do.
I don't think you need to necessarily refer to trouble the time period here. You could just give the commissioner the power by notice to specify who should or should not file, and then it would leave it to him or her to determine accordingly. Yes, because they can amend the notice each year or leave it, so it could be the same for a number of years, and then as the need arises, he would amend the notice.
The whole
So I was just discussing that we would amend subsection 1 to provide that unless otherwise required by a notice under the same section, the data controller is obliged to file the assessment, the impact assessment, and then the new provision would give the commissioner the power to publish a notice specifying the classes or kinds of data or data controllers who need to file the impact assessment.
In the first year of the regime?
No,
okay.
it would just give him the power, so he might not do one in the first year or 2 or 3, but then as the situation goes, he could then determine who he wants to file the impact assessment.
And that information will be made public? It's a notice, okay.
I was thinking publish in the Gazette or in such other matter as the commissioner might consider sufficient to bring it to the attention of the public.
So the proposed scheme is that everybody has to file this thing unless the commissioner issues a notice saying otherwise. So the notice will say those who don't have to file, or will say those who do have to file?
It could be either way, because it would provide that he could specify who doesn't have to file or who has to file, because he might determine that he wants the class of those who have to file is maybe bigger. So depending on how he comes down, he can say don't or do.
All right, members. How do you want to specify the amendment? Or we could come back to it at the next meeting? Because we wouldn't be, you know what I mean? Come back to it in terms of considering the wording and so on.
Well, I wrote something now, but I mean, you could consider it now. 47(1) would be amended to provide, unless otherwise required by a notice under subsection 4. And then we would have a new subsection 4, which would say that the commissioner may publish a notice in the Gazette and in such other manner as the commissioner considers sufficient to bring the notice to the attention of the public, specifying the class or kinds of data or data controllers to which subsection 1 shall apply or shall not apply. And then subsection 5, if we'd like to say that in determining the classes or kinds for the purposes of subsection 4, the commissioner shall have regard to the risks to the rights and freedoms of data subjects involved in processing the data concerned.
All right. I put clause 47 with the amendment.
Can we...
So, sorry.
My apologies. I would like to see that on paper. I would not wish to vote on something that I'm not seeing on paper. I'm sorry.
Unless the committee is just minded to agree the general principle that the commissioner would be empowered to, and then we'll come back with the wording. In principle.
I agree in principle. I just want to see it.
And there's one more amendment that we had recommended. There was a concern that additional details should be introduced or outlined in the legislation that would guide persons as to what would be what the data protection impact assessment should reference or speak to, and we are agreed that in the ministry that the clause could be amended to include a general description of the information that is likely to be required as part of the data protection impact assessment. So that was an amendment that we were proposing. The concern essentially was that the clause as it is didn't give any guidance on the face of it to data controllers that would be required to do the impact assessment, what type of information would be included in it. And we believe the GDPR does outline in their Article 35 general information that would be included in the data protection impact assessment. So we thought a similar, there could be an adoption of similar language, but generally a provision which provides some guidance as to what this data protection impact assessment would speak to. And
so you see
address.
one size fitting all in terms of the requirements of what would be in that assessment?
Yes, because it's an issue of determining, as I said before, what you are processing. It's your individual report. So the issue is a description of and it would be essentially description of the nature of the processing that you are doing as a data controller, your assessment as to the risk involved in your processing, and identifying in that report how you're going to mitigate. So it's still an individual. It's broad things, but it's individual to each data controller based on what they're processing. So you could have broad provisions.
Could that be condensed into a form that could be filled out rather than guidelines? Is it possible that you develop something that you can fill out, as it were?
Right. It says prescribe the form, so it would be in the form. But I think on the face of it, the concern was that just reading the...
I appreciate the concern. I was just trying to figure out how it could be reduced in a simpler way, whether there was provision for that.
Okay, with regards to clause 47, there was a request
Chair,
for...
Not to interfere with what just transpired, but just for clarity, wouldn't what you just said be envisaged under 47B, that in such form as may be prescribed by the Commissioner? But you want to be more specific.
I think the concern was, if there's a delay in prescribing the form, how do I know what to put in an impact assessment if I have to comply? I think that's essentially the concern from the stakeholders. So they're saying, can the provision, the clause itself, have some information within there that guides us as to what potentially we would be requiring us to put in this report or to address in this report?
By your act, wouldn't we want to give the data commissioner some discretion, some breadth in this regard without us prescribing specifically? Because I don't know if the circumstances over time may change.
But we could do, remember, to include, so you don't limit yourself in terms of...
All right. With regards to clause 47, there was a request from Member Morgan, and I think probably everybody would love to see what the amended clause would look like. And so we will, we will defer this clause until the next meeting. So we'll take clause 48, request for assessment.
There were no comments on clause 48.
I put clause 48 to members. If there are no objections, we accept clause 48. Clause 49, assessment notices.
We had 4 comments on clause 49 in relation to assessment notices. The Jamaican Bar Association notes that public authorities do not appear to be subjected to this section on assessment notice. Public confidence in the collection and processing of data by government departments and public authorities is significantly undermined if these bodies are not required to adhere to the standards outlined. The Jamaica Computer Society expressed the view that the assessment notice is overregulation or amounts to overregulation. The regulator should only be empowered to enter the premises of the data controller after the filing of a complaint from a data subject and after the data controller has responded to that complaint. NIDS noted that there was an overwhelming concern that Clause 49 may lead to compromise of personal and identity information contained in the National Civil and Identification Database or by other data controllers during such compulsory assessments. This is because the Act fails to provide for a clear and precise system under which such assessments should take place. They note that the provision fails to set out the factors that will inform the Information Commissioner's decision to serve an assessment notice on a data controller. They recommended that the powers be exercised under Clause 49 not to be exercisable where another enactment bars such access, and directed us to the UK Data Protection Act as amended, in relation to a code of conduct for assessment notices. They thought that that's something that we should adopt. Their concerns were that they raised concerns about the audit provisions which have been afforded to the Commissioner pursuant to Clause 49. The exercise of this power by a Commissioner can lead to tremendous disruption in the business of the company as well as concurrent costs to be incurred. The enforcement provisions under the Act in general, they thought were wide and should be suspended for an initial period of 24 months after the enactment. So with regard to the comment by the Jamaican Bar Association that public authorities appear to be exempt from this clause, the committee is asked to note that the Commissioner's powers of enforcement apply generally to data controllers and as such will be applicable to public authorities that are data controllers, save and except public authorities that fall within the definition of security or intelligence service under Section 5, subsection 8 of the Access to Information Act. And in that regard, I'll direct you to Clause 50, subsection 4, that notes that nothing in Section 49 authorizes the Commission to serve an assessment notice on a member of the judiciary or a body specified in Section 5.8 of the Access to Information Act. That is, bodies falling within the definition of security or intelligence services. On review of the concerns raised by NIDS, the Ministry concurs that to provide greater clarity with respect to service and execution of assessment notice, a provision can be included in the bill which would require the Commissioner to prepare and publish a specific code of practice to govern assessment notices, and outlines the factors which a Commissioner must consider when developing that code of practice. So essentially what we're saying is that there could be an amendment to requiring the Commissioner to issue guidelines as to how he would publish and or give effect to or issue assessment notices and on what basis he would be doing, or he or she would be doing that. And I'll just note to members that the UK adopts a similar kind of situation where where the Commissioner is required to issue guidelines or a code of practice in relation to enforcement powers, and to specify what the factors that would specifying the factors and the time and provisions regarding the circumstances under which assessment notices will be issued. So we do have an example of that. With respect to the concern raised by the Jamaica Computer Society regarding the onerous nature of the assessment notices, the Ministry is of the view that the scheme of the legislation is such that the Commissioner must have the authority to conduct an audit of the processes of any data controller, whether acting on a complaint or on his own volition, to ensure that a data controller or data controllers are acting in accordance with the Data Protection Bill. we don't see it as being onerous, but rather as proactive rather than and preemptive approach by the Commissioner to preserve the integrity of the data protection regime. We do not recommend, as posited by Flo, that the enforcement powers of the Commissioner be suspended for any further period beyond the transitional period contemplated by the legislation.
All right, I put clause 48 with amendment. No, sorry, 49. 49 with amendment. Regarding the Commissioner's ability to issue guidelines or assessment notices specifying time limits, etc. Ms. Murray, if you could kind of rephrase that amendment for me, please.
It would be an amendment to require the Commissioner to prepare and publish a specific code of practice to govern the issuing of assessment notices. And that code of practice would outline the factors which the Commissioner would consider the factors essentially that the Commissioner would consider when he's issuing assessment notices. So it's just to empower the Commissioner to prepare and publish a code of practice in relation to assessment notices.
All right, I put 49, clause 49 to members, and that is the last clause for this afternoon. Yes. Oh, you want to stay?
Minister Chair, we actually don't have any comments after 49. We don't have any comments on 50 and 51. The next set of comments is 52. So.
All right, so we'll take them in block.
I throw the 2 out.
49, clause 49, 50, 51. I put clause 49, 50, and 51 to committee members. There, 50 and 51. If there are no objections, we'll accept 50 and 51. Thank you, members. All right. Is there any other business? What's the date? What's next one you said? October 30, okay. All right, the date of the next meeting is Wednesday, October 30th, 2019 at 2 p.m. sharp. Huh? So let me say thank you to the Office of the Parliamentary Counsel, the Attorney General's Chambers, Legal Reform Department, Ministry of Science, Energy and Technology, the Houses of Parliament, and to all the members who made an effort to be here today. Thank you so much. Meeting is adjourned.
You never put up a fight, no. Paradise Plum, just know me like we do. We never had to say a word, not a sound. Silence, you baby. You never put up a fight, no. Paradise Plum, you just know me like we do. We never had to say a word, not a sound. Silence, you never put up a fight, no. Paradise. You nobody put up a fight, no. Paradise Plum. And keep it locked to PBCJ. This is your girl, Naomi Cowan.